Hello, I'm going to be quick, so we're not going to go on forever, I don't think. I think I've only got 15 minutes anyway to bore you guys, and so audible snoring is allowed. I guess I just wanted to talk to you today about this Counselling Notes Protect service that we've set up and about the sexual assault counselling privilege that applies to domestic violence matters, but it also may come in to federal matters eventually, and so it's probably a good thing to get your head around the concepts of it. It's a partnership between Legal Aid and Women's Legal Service, and I'll talk about that partnership further on. The sexual assault counselling privilege came about on the 1st of December 2017 in Queensland, and it was part of the reforms to our legislation in line with every other state in Australia. So we were the last state in Australia. We're 20 years behind New South Wales, who's done this. Our legislation is modelled on theirs, and it's modelled on their legislation from around about 2012. And so lots of the case law we've taken to inform ourselves about this legislation has come from New South Wales. Across Australia, there's various models. Our model is one of absolute privilege and qualified privilege. Tasmania's got absolute privilege on all their counselling records, and so there's different variety across Australia. It's come out of the Not Now, Not Ever report. It's recommendation 130, I think. I always get that wrong. And it's come out of research that shows that unless you protect people's counselling records, they won't get counselling if they're victims of sexual assault, and they won't make those complaints to the police. What is it? It's a privilege that's enlivened once someone makes a complaint of a sexual assault offence and there's court proceedings on foot in relation to that offence. And it applies to criminal proceedings and domestic violence proceedings, like I said before. It doesn't matter when that offence occurred, so it could be historical sexual assault offences. It could have happened 5 minutes ago, 5 months ago maybe. The model we have is one of qualified privilege and absolute privilege. In domestic violence proceedings, it's a model of qualified privilege, and so you need permission from the court before you can access anybody's counselling records. In criminal law proceedings, there's an absolute privilege at the lower courts, and then once matters get committed up, it's a qualified privilege for trials and sentencing, and there's an absolute privilege for bail proceeding. So it also applies to any civil proceedings that come out of those domestic violence and those criminal proceedings, and it's an absolute privilege in those civil proceedings, and that's why it's really important to protect the counselling records in domestic violence matters and criminal matters at this stage, because later on down the track, if that privilege is waived, then in any civil proceedings down the track, the privilege is also waived in those matters as well. So what is qualified privilege? Qualified privilege, I think I actually jumped over a few slides there in my haste. Qualified privilege means that you need permission from the court at 3 stages in matters. You need permission to subpoena counselling records, you need permission to inspect and copy those records, and you need permission to use that evidence in court. And it can be either written records, it can also be oral records. So it might be the people who you subpoenaed to appear in court that you need leave about. The privilege applies, and like I said before, it doesn't matter when the sexual assault offence occurs. It doesn't apply to those forensic investigations that's made when people are raped. So at that stage where you have that rape kit type scenario, it doesn't apply to any of those assessments, but it could apply to conversations around that assessment. And so it could be that in some of the New South Wales case law, people were being assessed for the rape, but they were really upset and they were talking to the nurse, and they were, the nurse was giving them support, and those conversations with the nurse was deemed a protected counselling communication and was privileged in those scenarios. There has to be this thing called an originating step, and that's becoming less and less relevant as matters are going along and as time's passing. For domestic violence matters, it needs to have been an application filed before the 1st of December, after the 1st of December 2017, and then the law is fairly ambiguous, or the legislation's a bit ambiguous. It says any decision made about a domestic violence order after that date. And so our understanding of that is that if you've had an order made before the 1st of December 2017, it might be an application to vary that order, that this privilege would be enlivened. It might also be that there's a breach proceeding or something like that after that date where this privilege is enlivened. This one talks about criminal proceedings. In criminal proceedings it's different, and I'll skip over that. But domestic violence proceedings was the one that I was talking about. In criminal proceedings, if matters are being investigated, once charges are laid or arrests are made or complaints are made, they all have to have been made after the 1st of December 2017. What is it? So what is a protected counselling communication? It has to be made in confidence, and that's probably the most important point about that, is there has to be an understanding of confidentiality around it. It can be by a counselled person to a counsellor, it can be by a counsellor to another counsellor to further that process, and it might be by a family member about that counselled person to the counsellor. It can include directive references to the offence. It could be something totally separate from the offence. So one of the cases was where a couple went to relationships counselling, and then 5 years down the track there was a complaint made of sexual assault, and it was deemed that even that relationship counselling 5 years ago is protected. So once this protection comes in, or once it's enlivened in the court proceedings, then all of your counselling records are then protected. I've been giving advice on a domestic violence matter, and it was a domestic violence matter where an allegation was made, or it was raised in the application, that the aggrieved had been sexually assaulted when she was overseas, and when she came back to Queensland she started a new relationship, which was the domestic violence relationship, and the respondent in that relationship has now tried to subpoena all her counselling records for who knows what reason sometimes, but for a reason. We're trying to work that out. But what we're saying is, well, actually those are all privileged. She's raised that allegation of sexual assault in those proceedings, and so therefore all her counselling records are now privileged, and you actually need leave from the court to subpoena those records. The definition of a counselled person, they have to have been to a counsellor as defined by this Act, so not as defined as what people think a counsellor is. And they also have to be a victim of a sexual assault offence. A counsellor, the definition of counsellors and counselling is really broad. So a counsellor might have had some training, they might have done some study, they might just have experience related to the counselling process as it's defined in this Act. And it can be paid or voluntary, so you don't even need to be paid to be a counsellor. Whoa, sorry. Okay, counselling is really broad as well. So it can be listening and giving verbal support, and that's counselling. It might be giving advice and giving treatment, but it doesn't have to be that. I was in the Brisbane District Court yesterday and I was speaking to a practitioner there, and she said to me, well, we're not trying to circumvent this sexual assault counselling privilege. She said, but why we subpoenaed the counsellor's records was that she just has a certificate in prayer ministry, and so she's not a counsellor. And I said, well, actually, the definition's really broad and lots of people are counsellors. So ambulance officers can be deemed counsellors, nurses can be deemed counsellors, a whole range of people can be deemed counsellors in this legislation. What you need to do under this legislation when it's a qualified privilege, so in those domestic violence proceedings, is that you need to apply for leave from court to issue those subpoenas or to get that evidence into court. Now, you need to do that anyway under the Domestic Violence Act, and it's just another reason why you do that. The law around this, though, says that you actually have to give notice to people that you are going to apply for leave. And so that notice needs to be given 14 days before that application for leave for those records is given. It's in the form of a letter, and you have to send it to each party, but you also have to send it to the counsellor. And if the complainant of sexual assault is not a party to the proceedings, then prosecutions has to give that notice to the complainant. And so that means that for the first time under this legislation, counsellors and complainants have standing to come to court and object to their records being used or to those records being used. The notice has to state, it's got to be in writing, it's got to state that you're intending to make an application, it's got to describe what particulars of the counselling records you want, and it's got to say that they also have standing to appear. When the court's assessing the leave issue, they actually have to weigh up a whole balance of factors, and I think I just went too far again. And this is the 3-limb test that they have to apply. They have to show that there's substantial probative value in those records being used. In criminal proceedings prior to this, all you had to show that it had a legitimate forensic purpose, which is a really broad test, and everything got in. This time, you have to show that it goes to one of the elements. So in a domestic violence proceedings, it either has to go to the relevant relationship, it either has to go to an act of domestic violence, or it has to go to the element of necessary or desirable. And then you have to show that there's not similar documents being able to obtain or with similar evidence in something else that's not someone's counselling records. And so a case example of that was where there was a group counselling session and someone made an allegation of sexual assault in that. And the matter went down the criminal path and there were criminal proceedings, and they sought to get those records from that group counselling session. The person had also gone to a Centrelink work meeting, had said the same thing, and so what the court said was, no, actually you can get that same evidence from the Centrelink work meeting, and so you don't need the counselling records. And then the third part is that you have to show that the public interest in admitting that evidence, so fair trial and all those things, has to substantially outweigh the public interest in keeping that counselling record confidential and protecting that person from harm. And so that's a really significant point, because before you just sort of did a balancing exercise, this time says it has to substantially outweigh that, which makes quite a difference. And when you're looking at those things, you've got to weigh up all these factors when you're thinking about that public interest test. Some time to read that. You can waive or lose your privilege. You have to be over 16 years of age. And I think when we were talking at one place, they were saying, well, why 16 years of age? And I assume that's because it's the age of consent, is 16 years of age. I don't know, I'm open to anyone having other ideas. You have to have capacity, and you have to have consented to the production of your counselling records. And that consent has to be in writing. So we've had instances where people have gone, yep, you can have all my records. And the court or the case law in New South Wales has said, well, that's not proper consent. You actually have to consent to the particular records being used, and why you're consenting to that. One of the counsellors that I worked with and one of the complainants that I worked with just recently was really good at keeping her records very separate, and so prosecutions wanted all of the counselling records because for some stupid reason, I think, the defendant had gone into the counsellor and made a confession that he'd sexually assaulted her, the complainant, and prosecutions wanted that for their case. When I went and talked to the counsellor, she said, yes, he did do that, but she'd actually made a really separate record of that, and so there was no other counselling records included in that. And so when we talked to prosecutions, we said, well, you actually don't need the counselling records, you can just get the information you need by subpoenaing him, and we don't need to think about privilege and she doesn't need to waive her privilege. And remember what I said, that there's long-term consequences if you waive your privilege for other court matters. So who are we? It's a partnership between Legal Aid and Women's Legal Service. Julie Sarkozy is my co-worker in Women's Legal Service, and we've been up and down the state thanks to our funding to tell people about this and boring them all. We have statewide numbers and we have a 24-hour turnaround to calls that come in. We've got a gendered model because we've got Women's Legal Service on board, and so Julie does all the female victims and Legal Aid will do all the male victims and or complainants, and we'll do anybody who's also a client of Legal Aid as well. What do we do? For counselling services, we give advice and task assistance and we do training. And for complainants of sexual assault, we give advice, task assistance, and we'll represent them in court. That's it basically. We're getting clients slowly trickling in, so it's still getting off the ground and we're still trying to get our head around all the nuances that come about with it. But I guess what I'd like you to think about though, if you have domestic violence matters where people are asking for counselling records, give me a call. I'm happy to talk to you about what to do about that, and I have draft submissions made and all sorts of things. But also in those domestic violence matters, if you hear that police are going to go on and make assault charges and things like that, then we'd be really interested to hear, because I have this fear that counselling records are still getting into the courts, especially in criminal matters, and we're just not hearing about it. The courts are still just stamping those subpoenas and letting it through. That's it. Thanks very much.